I'm Jared Effler, District Attorney General for Tennessee's 8th Judicial District. Union, Claiborne, Campbell, Scott, and Fentress counties. I'm proud to be a career criminal prosecutor. I started as an assistant district attorney in 1999 working for District Attorney General Paul Phillips, and I served in that capacity until 2014 when I ran for district attorney, and I was fortunate enough to be elected and been honored to serve in that capacity since then. It's just a fancy way of saying it's two parts. Anytime someone is found guilty by a jury in Tennessee, there will be a subsequent sentencing hearing, and that's typically performed by the judge, and it generally follows a few weeks after the jury verdict so that the courts can gather information about not only the defendant, but the victim as well. In most all cases under Tennessee law, sentencing is done by the trial judge, not the jury. So it's the jury's job to determine guilt or innocence. Once they complete their job, then it will be the judge's job to pronounce sentence. Many defendants are free on bail during the jury trial, and it's oftentimes within the judge's discretion whether or not to allow that defendant to remain on bail pending sentencing. However, some cases require the judge to automatically revoke bail for a defendant pending sentence, and those are the most serious cases, the cases that generally require incarceration where the judge has no discretion at sentencing. Those are the cases where you will see bail automatically revoked. Depending on the crime, sentences can either be, completely served on alternative sentencing, what we commonly refer to as probation. We could have a blended sentence, what's referred to as a split confinement, where the defendant would serve some time in the county jail followed by supervised release, or we could have a sentence that's entirely incarceration. And again, that's our job as prosecutors to explain to the victims what the options are, what the possibilities are going to be going into that sentencing hearing. Certainly, suppose we have someone that's convicted of second-degree murder and that person has no prior felony convictions. That person is looking at a sentencing range of 15 to 25 years. Our judges will consider both mitigating and enhancement factors. Mitigation towards the defendant receiving the low end of that range, enhancement towards the defendant receiving the high end of that range. And it's up to the respective parties to advocate their position, whether or not the mitigation outweighs the enhancement. And then the judge has the option of considering all of those factors and determining what the appropriate length of sentence is. Going back to our hypothetical person charged with second-degree murder, as a prosecutor, we would never be able to introduce at trial the fact that that person has a lengthy history of driving under the influence convictions. That would not be relevant at the trial. However, as we shift to the sentencing hearing, at that point, trial judges can consider the defendant's criminal history, and at that point, those DUI convictions would be relevant and would be admissible. We would want any criminal history or any criminal behavior by that defendant, we would want that to be admitted and be brought to the judge's attention. Concurrent is just think of it as running at the same time or back to back. When we say concurrent sentences, those sentences are running at the same time or simultaneously. When we talk about consecutive, those sentences would be running back to back. Suppose someone breaks into your home and they're convicted of aggravated burglary and theft of property. They receive a 1 and 3 year sentence on those offenses respectively. If that person is sentenced to a consecutive sentences, that person's serving a 4-year sentence. If they're sentenced to concurrent sentences, that person is serving a 3-year sentence. It's just a fancy way of saying, at the same time or back to back. I believe it's essential for the court to know how this crime has impacted this victim or how this crime has impacted their family. And we always work with crime victims and let them know the importance of that. Please take the time and submit your victim impact statement. And I think it's also important to note that crime victims have the option of entering that victim impact statement in person. And we always, as prosecutors, discuss that with them. You can submit a written statement, or you can pronounce your victim impact statement in court at the sentencing hearing in front of the judge. Personally, I believe it's much more impactful if victims are able to say how the crime has affected them in court in front of the judge, where they can have that one-on-one contact with the person who's going to be announcing sentence. Well, there's certain things that victims aren't allowed to say, just like attorneys aren't allowed to say. We always advise the person submitting the victim impact statement not to address the defendant directly. We know that's hard. And we always tell victims it's important to focus on, in homicide cases, to focus on the victim. All the way up to that point, the focus has been on the defendant. And I believe it's our job as prosecutors to explain and encourage the victim's family, let's shift the focus to the victim. Let's let the public know how about your loved one that we no longer have with us. And that's what we want to focus on at sentencing is, what type of person their loved one was, how their loss has affected them personally, and how that loss has affected other people in the community. Typically, we would see it in the context of a homicide case where the decedent leaves behind a large family, and we would have to work with them to designate a spokesperson for the family to submit the victim impact testimony. There's so many unknowns going in. There's no way to know what that sentence is going to be until that judge pronounces it, just like with a jury trial. So there's a lot of stress, and we need to be there as prosecutors and support those victims and to answer any questions they may have. I hearken back to a case, the first murder case I ever lost was the result of a jury verdict of not guilty. And honestly, I was heartbroken. I was a young assistant district attorney. And I'll never forget the very next day, the victim's mother brought me a bouquet that she'd picked out of her garden. And she wanted me to know that I appreciate you trying. And I think that's so important for prosecutors to remember. The victims want someone just to go to court and stand up for them and be their voice.